Creditors in Commerce Private Workshop Sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in the sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in the sessions. Each transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein. Each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in the sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in the sessions. The discussion of ideas or procedures in the sessions are not exhaustive of the subjects being discussed in any one session. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in any one session, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of each party to understand his or her own transactions and to apply the appropriate and complete concept.
What is authority? How is authority created? Did somebody say force? We believe. Some people believe that. Influence, huh? By agreement, authority is granted by one party to an accepting party. The party that accepts the authority then has a fiduciary duty, is compelled in their authority that you've granted them. Nobody has any authority other than that which you grant them. Have anything to share on authority?
Yes. Regarding authority or granting or contracts, who is the authority? It's just you. Now, it's hard to you're going to have to get into what is a contract and how are they. It's kind of a neat quote I got once. It's, contracts are express or implied. The express are manifest viva voce, by the voice, or by writing. The implied are shown by silence, by acts, or by signs. Contracts are express or implied. The express are manifest, viva voce, or by writing. The implied shown by acts, by silence, or by signs. Get over there. Officer Smith. Do we have a contract? You bet you do. As silly as that sounds. And it might be a little easier for you to understand when you go to a restaurant and you order up a bunch of food off a menu. I'd like the steak, and I'd like the potatoes, and I'd like this. The waiter takes the order. He doesn't say, well, are you willing to pay $37.50 plus the gratuity? And yes, I'm willing to pay that. Are you willing to bring it when it's cooked correctly with no bugs and this on? We don't go into all of that. It's an implied contract. Or partial implied, partial express. Most important thing to understand is a lot of people think you can get a hold of Deepak, my assistant, or myself somewhere in here, and we can get you a copy of some contract material out of a book. On the page 50 of Brian Blum's Contracts, Explanations, and Examples is really good. It says, in colloquial speech, people often talk of signing a contract. That's in quotations. People often talk of signing a contract. Strictly speaking, this is inaccurate terminology. The contract is the legal relationship between the parties, and the document that is signed is actually the record / and or memorial of that contract. I never signed a contract with you. Yes, that document's also referred to as a contract, But in reality, the contract's the legal relationship you have. I'm doing a little action for a guy that's having a problem collecting from the insurance company. This particular insurance company says, well, that wasn't covered. This $8,000 worth of theft wasn't covered. It's true, it's not. But when he gave the agent the money and the agent took it, the agent told him it was. So when they said your claim has been denied, we simply conditionally accepted upon proof of claim that in fact the agent did not represent that that was such the case, and the agent gave a little affidavit in support. Notice to the agents, notice to the principal, and when the agent represents the principal, and in this matter where they took the money, he will collect on it. He just got to simply enforce his claim. So what is a contract? Boy, there is your key for all of you to understand what a contract is. So you must get a hold of some material regarding contracts, because they're an esoteric concept. Most lay people think that a contract's nothing more or merely a signed document, etc. Yeah, that is one also. But your behavior constitutes a contract. And I can enforce a verbal contract every bit as easily as what a layperson refers to as a written contract can be enforced. Not a problem. Talking to one young lady, and she wants to maybe bring something against the gentleman that she has a grievance with. She said, well, what do I do? Well, let me tell you, with this course and this material, that guy's toast. He is. Anybody is. If somebody makes an agreement with you, well, I don't know, it's not in writing. What's writing got to do with it? Contracts are implied, right? Contract's a contract, ladies and gentlemen. If I was really a dastardly guy and I lived in your neighborhood, maybe I send you a notice. Hey, I've been watching the neighborhood this last year. Been going out once a week on your behalf. I kept an eye on it, seeing to it nobody robbed your home. You didn't get robbed this last year. You owe me 10 grand. And I send it to you. A little appropriate material, this and that. What are you going to do with it? Have that nutty Gordon, throw it in the trash. Ooh, you shouldn't do that. Might be bad. I might send you a second notice, give you a notice of fault, opportunity to cure. Then I might send you a notice of default and dishonor. And you might have a $10,000 lien on you. You go, how the hell, what you doing? Well, what did you do? Did you agree with me or didn't you? What did you do when I sent you the notice? Nothing? No, that nothing was something, huh? I have a lot of people tell me, oh, they ignore me. What do you mean they ignore you? They agreed with you. What more do you want? Well, no, they didn't. They just ignored me. Okay, I can see that we're having a little trouble here. If you get into these simplistics of what it is, and that's why reading a book like Brian Blum's or Williston on Contracts or Restatement Second, beautiful examples, beautiful understandings for what really contracting is. That's some of the biggest things or disability that the layperson has, is understanding that you're entering into a contract all the time. Almost the whole procedure of human life implies, or rather is, the continual fulfillment of contracts. It's all that binds us together as a society. That's it. One young man I'm talking to here, we're talking about driver's licenses. One real good example that I can pick on is Deepak. No, this guy's something else. This guy's got like 29 tickets, 10 arrest warrants, failures to appear. He's crazy. He's the nuttiest guy about this stuff I ever saw. And he's my assistant. Now the other day Deepak says, hey, I want to come into honor. I want to quit doing this stuff. Now how's he gotten away with it for so long? Unbeknownst to him, like Brandon's buddy, he's been doing conditional acceptances with these policemen all the time. Cop run his plate, they pull him right over. He's got all this unanswered stuff. And he's always going, well, can you help me? He's asking the police, I said, what have you been telling? He goes, I just say, well, can you help me? Yeah, they let him go. They keep letting him go. They're enabling this guy. It's beautiful. He has done conditional acceptance without ever realizing it. Now, I think his rope was coming in an end because he got stopped again the other day. This is real regular. This is like You know, it's the worst luck or the worst habit in the world. I don't know which you want to call it. He ended up going into court, and they want to contract with him. So he says, God, what do I do, Gordon? I said, well, let's do this. Let's file this paperwork. Let's get a little abatement of proceedings pending an administrative proceeding by him to settle the matter. So he takes all that in because there's no case filed, so he takes it in, gives it to the bailiff, to give to the clerk, to give to the judge, etc. And the bailiff says, we'll just use Deepak's first name for simplicity. Are you Deepak? He says, I'm Deepak. I am here today as Deepak third-party interest intervener, for the purpose of helping the parties settle all claims or charges outstanding. Bailiff says, are you Deepak? He answers. This is just like, I hadn't heard this one before. This went back and forth, he says, for like 8 minutes. That's a long time. It's got to be like 30, 40, same question, with very little variance. He finally says, when were you born? He says, Deepak was born, and he gives a date for Deepak's birth. Then he says, where were you born? He says, Deepak was born in Baltimore, Maryland. Bailiff finally gives up. He never got jurisdiction. He never got him to enter into a contract where he could jack him up. So Deepak's waiting, and pretty soon out comes a DA type and walks up to him. Because I tell a lot of my students, only answer questions with questions. And then later on I say, got a new rule. Only answer questions with questions. Tell us time to answer the question. Huh? Yeah. There is a time. So Deepak, this DA comes out, walks right up to him, doesn't introduce nothing, and says, can you get a license in 60 days? He goes, sure. And Deepak says, I'm thinking, well, a fishing license, or this license, or that license, get all sorts of licenses. So what was wrong with saying that? They called the hearing up, and then they're bringing him up in threes in this traffic court, so they called Deepak up there. And the judge says, I see this matter's been put off 60 days. Deepak says, well, you know, I've got to go on this tour. He's a musician and very successful. I got this tour, and I'm going to be gone through October, etc. And he had planned it. And judge says, well, and could you put this off till after that instead of 60 days? And the judge says, well, how about in November? So Deepak's got 120 days. Offer and acceptance, offer and acceptance. Beautiful thing. Here we got this guy that's obviously like an offender extraordinaire. This is the poster child for this kind of behavior. And he gets 120 days. They honored him. He wants to come in honor. They know he wants to come in honor. He filed it. He put in the paperwork, a forgive me letter, a little of those kinds of things for his behavior, because he genuinely wants to come into honor. He's not playing games anymore. He wants to be honorable. I guess we could talk just a moment about his bad habits, because that bad habit of his, him and I are over at my buddy's place over in Hollywood there, and we're next door to the Palm restaurant, and they can't be parking there when they come in the afternoon for lunch and stuff, so the parking lot guys are showing up, and they said, hey, could you move the car? So Deepak moves it from this side of the parking lot to that side. I said, what is wrong with you? What are you doing on one side of the parking lot? You know, can you move the car? The guy says, there's parking on the street. So I pull my car out, and I'm waiting for Deepak, and he pulls in, and he pulls into an authorized vehicle-only park. And I said, on the back of the Palm restaurant, I said, what the hell is wrong with you? Because he gets out, and he comes out and says, you're not leaving it there, because I don't want to be dealing with him with the thing towed later in the afternoon, right? I said, there's parking up here on the street. Now get him. Habits are bad, but he's trying to break them.
But then Deepak says, you just asked me to move it. So I moved it.
It's all about contracting. There it is. You're the contractor. They can't do anything to you. They, the government, your neighbor, me, Brandon, Jack, we can't do anything to you that you don't authorize. You are the authority. You are the contractor. Sovereignty itself is not subject to contract, for it is the author and source of contract. You're everybody's sovereign. That's the real rub out here. Everybody's been given authority by God. And all these governments know that. Now, in a communist country, etc., I can't attest to, but all civilized countries, Canada, Australia, Japan, New Zealand, you name it. All civilized countries work off a contract. If you don't make an agreement, they don't have it. And you can go make an agreement. And as you learn these principles and concepts, authority, you are the ultimate authority, ladies and gentlemen, for anything you want. What is it you want? Do you want $40,000 for a $10 plastic chess set? Seems ridiculous, but hey, if he wants to agree, it's on him, isn't it? If a certain large-sized retailer would like to pay 10 grand for trying to compel the disclosure of a Social Security number on a $186 check, it's their prerogative, isn't it? And are they going to pay it? They pay that, or they pay $60,000 if they want to mess around with it. And if they feel like they're dealing with it. I had a certain retailer that wanted to play games that way because their staff felt that you had to disclose a Social Security account number to cash one of their own cashier's checks. Are you sure? I love that statement. Are you sure? Upton Sinclair. It has cost many a man life or fortune for not knowing what he thought he was sure of. A few years back, I thought I was Gordon Hall. I thought I lived in United States. And I thought United States was my country. So now I know, what do I know? I realize I don't know very much, and that keeps me open-minded to all sorts of new concepts and thoughts. So as you hear these things that Brandon, Jack, and I present, open your mind. Does it sound good? I'm going to tell you, we don't have a chance against a force as mighty as the government of the United States. They have aircraft carriers, nuclear weapons, and armies. That's not for us, not for those that are in harmony. It's for those that are not in harmony. And since I don't have that kind of weaponry and force, that kind of might doesn't make right. And you've heard it. What's mightier than the sword? The pen. Now you know why. You could do so much with the pen. So, Brandon, back to you.
Jack, you have anything on authority?
I don't know. How long do you want me to go?
As long as we can benefit from it.
Do you want to put the dual trusts up on there, that first diagram
we were
I
about
gave
to
you
get
this
into
morning?
contracts and trusts, so I was thinking we should probably go
I think
into
it
that.
should be in a folder on there that says something about Chicago, and it's probably the dual trusts. I think it's PowerPoint.
Okay, yeah,
How
we're
many-
actually, after authority, we'll go into structures of trusts and contracts.
How many people in here have not seen my chart on dual trusts? A lot of people. Okay. I believe they're all going to get a written copy or a printed copy of this, won't they, Brandon, before the end of the week? Okay. If it is, then you won't have to make this diagram that we're going to show up here. It's going to look a little bit complicated, but it's kind of a roadmap so that you can understand what you are doing in this relationship between parties. And I will also try to bring that back to The Wizard of Oz, because in that particular movie, you have Dorothy when she appeared in Oz, and she had basically three entities following Dorothy wherever she went. And those three entities are your shadows in this defective world of Oz. There is the lion, which was the only living character of the three. There was the Tin Man, and there was the Scarecrow. Remember, in that story, Dorothy had a problem back in Kansas, where she came from. Before she is morphed to Oz, wasn't she involved by trying to tell her little dog Toto to give the neighbor lady, Miss Gulch, a bad time? Wasn't Toto kind of ripping up the garden, and didn't Miss Gulch claim that Toto had bit her in the thigh? And she came over to Aunt M's farm complaining about Dorothy and her little dog. And when she came over there, she produced a piece of paper that she said was a writ from the sheriff. And the writ from the sheriff was the law writ that authorized Miss Gulch to seize Toto, to take Toto back to the sheriff, where the sheriff was going to destroy the dog on the grounds that it was a vicious dog. And no matter what Dorothy did to plead to either Miss Gulch or to her uncle or Aunt Em not to let her take Toto, Miss Gulch said, "Are you going to violate or go against the law?" And Aunt Em finally said to Dorothy, "We cannot go against the law. Give Toto to Miss Gulch." Wasn't Miss Gulch someone who was making a commercial charge against Dorothy and her dog? And the law was only going to do an execution because Dorothy had no remedy whatsoever in law. Well, remember, this whole story came out of a book that was written after 1933. And in 33, when we lost our money, we lost the capacity for the courts to hear any issue in law, because any criminal or civil case heard in a court in law could only be executed, the judgment could only be executed in terms of lawful money. There is no lawful money to execute a judgment when found. Why would the courts exercise any authority in law when the final judgment was incapable of being executed because there was no lawful money? So there was a paradigm shift going on in 1930s from law to equity. Isn't the definition of equity a procedure which is put in place of law when there is no remedy afforded in law to whatever the situation is? So what happened is Miss Gulch went to law in Kansas, and when Toto escaped from the basket on her bicycle and ran back home, then Dorothy could only figure the only remedy was for her and Toto to escape and go on the run so that the law would not execute on its order. Is Dorothy acting like a debtor, or is Dorothy acting like a creditor? Debtor. She's avoiding, evading, running away from her problem. Now, she ran away and she met this guy in this traveling wagon. And on the side of the wagon, it intimated that he was a fortune teller and that he could look into the crystal ball and let you know what's in your life. And it also said on the side of his trailer that this guy had credentials and had been before many of the heads of Europe, the heads of state, the crown, the king, and everybody else. So the presumption was this was a man of title that was well esteemed and could handle problems. He kind of immediately sized up Dorothy and the dog because they had their little suitcase. And he said, "Well, why don't you come in and let me read in the crystal ball here and let you know what you should be aware of." Did he not tell her to go back home again? Because you're never going to resolve your problems by running away and acting like a debtor. When she went back home, the storm was approaching. The window got blown out in her bedroom and hit her in the head, and she went into a sleep, a coma, whatever you want. And the next time Dorothy was back in Kansas is either when she woke up or came back to consciousness having been knocked out, or when she returned from the land of Oz. Take your pick of whichever one you want to choose. Now, when she was in the land of Oz, everyone she met in Oz was an alter ego of people that were on her Aunt Em's farm and back in Kansas. And so she was meeting all the same characters. The Wicked Witch of the West, which gave her so much trouble, was the spitting image of Ms. Gulch, the one who had been charging her back in Kansas. And you had the three characters, the Lion, the Tin Man, and the Scarecrow, were three of the farm hands on Auntie M's farm. The Wizard of Oz himself was that gentleman who she had met at the wagon, which had read into his crystal ball her fortune, telling her to go back home because her aunt loved her and she would get her problems solved back home. Now, when she was in Oz, she met the three characters that represented her in that land. There was the lion, and of course his problem literally was the fact that he had no courage. He was afraid. Why have you people not been going out and settling your straw man commercial affairs the right way? Is it because you have been afraid? Or was it because you were the scarecrow part? You had no brain with knowledge of how to do it? Or were you the Tin Man because the Tin Man was the corporate creditor for your one-man straw man corporation? And of course his problem was he had no heart, so he didn't care about your personal problems. But worse than that, he was rusted up. Dorothy had to oil him to get him to work because the creditor side of your corporate straw man has probably never, ever been used in your life to set off your debts for your straw man by going to the asset side of your account. So the Tin Man is literally the banker creditor for your straw man. The Scarecrow is the debtor receivable side, which you're really used to using because you love all those benefits and everything that you want to get. You just don't know how to pay for them to set off the account so that the debt collectors go away or so you get title to your goods. And it's all because of lack of courage. So everything they're telling you there in Oz, Dorothy had to go into this imaginary world, into the de facto world, into the public, to get a solution to her problem because there was no solution in reality because there was no lawful money, so there is no law to settle the case. You've got to go to equity. And when you go to equity, you find out that the guy that's at the top, this wonderful wizard, has all the knowledge, he has the brains, he knows what you want, he has the capacity to grant your wish, but he's waiting for you to bring him the solution, and you're not coming there because between your lion, your Tin Man, and your Scarecrow, you have not fashioned and set up your remedy. Now, once Dorothy got her remedy in place, and what was her remedy? She had to settle her commercial problem with the Wicked Witch of the West, who was the one who was always causing her, and her little dog Toto, I'm going to get you, the problem. And until she resolved that, she couldn't go back home to the natural law of Kansas because she was in a debtor capacity and she had to settle that account. Now, the reason we can't get to our remedies is because we've got all these outstanding debts, and they want us to go to Oz to settle them, and we don't know how to settle those debts. That's what we're trying to do. So the concept right now is authority. We have a diagram here of dual trusts. There is a horizontal line through the middle of this page. Think of it as a mountain scene out with a lake in the mountains. And the horizontal line is the shoreline of the mountain lake. And above that line, we have the peaks of the mountain. And below that line, we have the reflections of the peak in the lake. Because that's exactly what you're seeing here. there is a dual trust, which I'm sure we're going to talk more about today. Now, we've been talking about the fact everything is contract, but theoretically, if you're involved in contract, you need valuable consideration, lawful money. Since there isn't any that exists in the public anymore, theoretically, we cannot have any contracts between us because nobody's giving any valuable consideration. Now, there is a portion of law which said that when you operate in the capacity of a trust, you're operating in a very similar capacity to the relationship of contracts between the parties. But when you operate in a trust does not require lawful money or valuable consideration between the parties. Secondly, when you act in the capacity of a trust, you do not have to fulfill the contractual requirements of full disclosure of all the terms and conditions between the parties. How many patriots are yelling and screaming that the government has induced you into all of these, quote, contracts, unquote, but they didn't give us full knowledge and disclosure of what was going on? That's because without lawful money, they aren't contracts, they're trusts. And because they're trusts, not all parties to the trust have to be given full disclosure of the terms and conditions. So you've been lied to, but it's because you're involved in a public trust. And as the beneficiary of the public trust, we're going to see you're down in block 6 on this diagram, the lower right below the line, the trustees and the grantors do not have to give you full disclosure of what it is that you are involved in. Now, the purpose is talking authority. God has full authority for everything because He created everything in the universe. And as my friends have said, authority is granted or delegated from the top down. So when God created man, He gave man the authority to represent God as an agent in this whole process of applying God's authority in the earth through the agency of us, His creation. Now remember, originally government was instituted among men, by men, so who created the government? Mankind created the government, so who has the authority? Man has the authority over the creation of government. Government is an entity which creates other things like corporations. Who has control over the corporations? The government that created their creation, the corporation. Can anybody give authority to their creation that they were not first delegated to them? No, it doesn't exist. Since man was put in authority under God, which created government, which created corporations, we now have the United States as a corporation. And what is the corporation of the United States doing? It created fiction, straw people. They've convinced you that you are the straw person. Since government created the straw person, who controls your straw person? Government. But you believe you are that creation, but now you're confused because you went, I thought God created me and we created government, and I should rule over government. Yeah, that's true if you knew who you were, what your name was, or your capacity and authority, where you live and all these other things, but see, they've got you acting through the creation of the corporate government as a creation of them. And so the line of authority is totally inverted now because you are not acting in your proper role. You don't know who you are. So let's look at this chart. When it comes to a trust, there's three entities: grantor, trustee, and beneficiary. Now, above this line is the world of reality, which in terms of the nation is concerned is under the political power of the republic. Its rule of law is common law of the land. Below the line, we have the political rule of democracy. A democracy is operated under the rule of law of the sea, not the land. There is an inversion. Under the law of the land, what is the most important aspect of the law of the land? What is it there to protect above everything else? The life, liberty, and rights of all living men and women under the law of the land. What is the primary objective under the law of the sea? It's there to protect life of man and woman, but the man and the woman, or the men and women, are presumed on board a vessel. And the presumption is if the vessel is compromised and destroyed, then the purpose of the vessel to hold man and woman safe against the elements, drowning in the ocean, or if you're in a spacecraft circling the earth, if it were to disintegrate, you would have no oxygen. If the vessel is compromised, all life on board is gone. So the primary directive under the law of the sea is to protect the vessel, not the individual life on board. There becomes a problem. Because if you have many lives on the vessel, we may have to sacrifice one, two, or more in order to protect the viability of the vessel reaching the destination safely, so that as many lives as we can on board will be saved. But the rights of any one individual as to his right to live is no longer determined by the law of the vessel in that he's got an unalienable right. It is now centered in one title of nobility entity called a captain, who is the law of the vessel, which means the contract, which means whoever he says lives, lives, and whoever he says dies must be sacrificed for the greater good. And under the law of the vessel, you do not have any rights to go against the captain and object even though you are losing your life or your property, because the captain is given a godlike power of authority over life and death. And he has been given the authority to use lethal force through his agents on board if you resist. So whereas under the law of the land we all have unalienable rights to life, liberty, property, pursuit of happiness, when we change our location commercially onto a vessel, we have waived our unalienable rights to life, liberty, pursuit of happiness, and property, and we have acquired only inalienable privileges and benefits determined by the captain of the vessel in that law form. The money of land is lawful gold and silver. The money of the sea is choses in action and paper. What is our nation dealing with in terms of what we're using as a money since 1933? Isn't it paper, choses in action? Therefore, we have moved our nation under the law of the land into the law of the sea. We have changed the paradigm under which the authority has been handled down in order to deal with any of our commercial, civil, or political problems. Where was everyone in 1933 objecting and protesting to this? Aren't you aware today that the Coast Guard surveys the land and the Army dredges the rivers? What's wrong with this picture? It's all inverted. Isn't it true that Obama is the captain of our vessel instead of the leader of our nation? Isn't it true that Spock continuously told everybody on the Starship Enterprise that the individual rights of the few are outweighed by the needs of the many, because we are on a vessel under a different law form? So if you're going to understand what's going on and be able to get your remedy, first of all, don't you even have to understand who you are and what environment you're in? Because as being on the vessel, so to speak, since 1933, we have to deal with the procedures to settle our problems as though we were on the mighty Titanic, and that we have to deal with those issues. And if you were on the Titanic, did you literally bring your allodial land with you on the Titanic as the situs of your kingship and sovereignty? I don't think so. I think you left your castle back home when you got on the vessel. And so the only thing you have, so to speak, on the vessel in their system of law is basically a piece of paper that says, I have an interest in my castle somewhere. And that's all you've got. Remember, didn't Waterworld really tell us that land is rumored to exist somewhere, but that to our knowledge, nobody's run across any land in the previous near past that we know of, and no one's actively searching for it right now because the whole universe is covered with water. Wasn't it true that Kevin Costner's character was able to adapt and do well because he could breathe on the deck of his vessel with lungs, and he also developed gills so that he would be able to live in that environment also? So within your toolbox, you've got to be able to develop some gills to be able to run your paperwork through these admiralty processes to get some kind of a remedy. So all these patriots out there that are putting in their common law process and looking and demanding their Article 3 courts, I'm not sure what land of reality, as far as the system that they find themselves in, that they're adapting to well, and I don't know how their process is coming out, but I think the captain's court is probably humoring those people a little bit. And as to how much remedy they're getting, I don't think the captain's bench can give them much common law process remedy without it being purviewed through the process of Admiralty Maritime. Now, I'm not taking anything away from what you've heard so far this weekend, where Gordon has said, hey, look, You know, we live in the land of our reality. And if we want to create that contract in our reality and be that, we have the right to do that. And if we put that forward to them and they don't respond, then the reality of our agreement is what it is. But remember, to get a remedy, you need 2 or more witnesses to everything. One witness is doing it in the land of reality, and the second witness is to move your process from the land of reality into their world on the high seas, and getting them not to rejudge your reality, but to acknowledge that this is a foreign and alien agreement between the parties. And we're not asking you to rejudge it. We're asking you to look at it and to receive it as a valid process, having come from our land, which is here to resolve the issue in your land. So above this line is the republic. That's the reality. That's where we ought to be operating. But that world is alien and foreign to this public world that's here. The public world that's here is below this line. We've got to resolve our problems above the line, and then out of courtesy, we send them the record to their court below the line, not to be filed, but to be received, to be reviewed for correct process in granting all parties equal rights and equal opportunities and due process. And if that has been maintained in our system, and they had notice and opportunity, and they failed to respond, then in both the world above the line and below the line, it ought to be valid process which is agreed upon between the parties and by contractual consent or by treaty, because you have a trust above the line, a trust below the line, and you're just bringing the parties together as alien parties, asking them to adopt a treaty of agreement. And we should get our remedy. Now, the authority above the line rests with the living man or woman. That's in Block 1. That's the grantor to the trust. When you create the trust, it's created in Block 2. The trust may have the same name as the grantor. Block 2 is not officiated over by the grantor. A trustee is appointed or assigned to operate the affairs of that trust, and the trust usually has some kind of a corpus of property rights put into that trust, which become commercial interest, and the trustee has legal title, which is control over all of the attributes and aspects in the property that's been put into the trust. But the equitable interest of the property in the trust does not reside in or belong to the trustee. He only controls and manages it for the party who has the rights to use the equity or possess and use the property. The party that has the rights of use and equity is the beneficiary. Now, in this particular diagram here, for those of you that have gone through any of my work, you know, and we're not going to spend the time going through the history of the United States, but you know that a constitution is not what most people think it is. That if you look up the definition of constitutor, you will find that a constitutor is one who passes on his debt to a third party. Is that what you thought it was? So who were the constitutors of the Constitution of the United States of America? that was brought out of their convention in 1787 and adopted by the states in 1789. Wasn't it the national leaders of government who became the constitutors that wrote the Constitution? Their purpose was to pass on the national debt to a third party. They were looking for sureties. They were looking for backing for the national government in the commercial arena. Who'd they pick on to be the sureties? The states. So when the states adopted the Constitution, they became co-sureties of the national debt. Remember, they said it was to create a more perfect government. What was wrong with the government that existed under the Articles of Confederation? There were no sureties to underwrite the commercial performance of the national government. So what kind of problems did the national government have doing business with foreign nations? Nobody would do business with them because there were no sureties. So to create a more perfect business environment for the national government, they had to get sureties to underwrite their performance so that they could then, among the nations of the world, go out and compete internationally for all kinds of commercial contracts. Now, if you remember, once that happened, the United States had a debt. It was caused by the costs of the Revolutionary War. That was why they needed sureties, because they couldn't pay off that war debt. It led to the War of 1812 because the national government approved the first national bank in 1791. Was that a government bank? No, it was a private bank. What was its purpose? To hold all of the corporate assets of the United States government as surety for their international debt. So they had a private bank holding all of the assets of the government, and they had estates that were bound as co-sureties in case even the assets being held in the private bank failed. Now, where that comes in on our chart is, why did they start doing this registration and filing of individual birth certificates? Because when the birth certificate was granted from your mother, let's see, your father would represent your land law interests, your mother would represent your Admiralty Sea interests, right? Okay, so the debt that the national government is involved in, is that debt under common law of the land, or is that debt international under law of the sea? Law of the sea, okay? When they induced your mom to enter into a treaty and registered your birth certificate, they created a one-man corporation, mirror image to you, whose assets were pledged to underwrite the national debt. So they did to the people in the late 1800s, 1900s, in preparation for what was going to come, what they did to the states back in 1787. They got you to contract into being a surety behind the national debt. And so the beneficiary of your trust that was established, you were the grantor to the trust when your mother induced this birth certificate. And the trust is in the name of the certificate of live birth man. And the assets that the certificate of live birth man accumulates in this world are pledged to underwrite the government debt at the national level. So the government at the national level is the beneficiary of your trust. Everybody following so far? Has anybody usurped any authority that did not follow down the chain of command? Right on down the line. Did your mother understand what she was doing? Maybe not, but you know, when you're involved in a trust, we don't have to disclose everything. Now, they claim they set up a Social Security account. And they told you this is social insurance, so that if you really need it, you can get at it, right? They lied to you. The reason they set up that account is not to give you something, but to record everything they took from you. Because if they do not keep an accurate accounting of what they took from you, you might actually accuse them of theft, crime, or unlawful conversion. And I mean to tell you that every year, if necessary, the IRS will send out Guido to make sure that you are reporting your wage income. For what reason? Because they have to accurately determine what they owe you. They're not trying to get a tax out of you. First of all, the government doesn't live off the taxes. Aren't all the tax collectors private? Is IRS part of the government? No, they're private. Is your property taxes paid to the county? Hell no. It's paid to Fred Jones, county treasurer. You're paying Fred Jones. He's a private tax collector. Didn't you ever read in Scripture in the New Testament where everybody was upset about the private tax collectors? Nothing's changed. What are the tax collectors collecting? Money from the debtors. Who are they giving it to? The government? Hell no, they're giving it to the creditors. Debtors can't win, creditors can't lose. Where does the government fund its operation? You'll see in a minute. Aren't they the beneficiary of your trust? If they're the beneficiary of their trust, then look what they do down in the public. They mirror image everything we've done. See, the beneficiary is on the republic side of the government, which is the lawful side. Doesn't it go through agents to the Secretary of Treasury, Washington, D.C., Geithner? Doesn't the Secretary of Treasury, Secretary of State, Attorney General have to expatriate their corporate citizenship in the U.S. under Title 22 to take those offices? They are the trustees in private to protect the assets in the republic. But in the republic, the lights are on and nobody's home. So the three trustees are protecting the assets of the living men and women in the republic. There's a movie coming out here, I think, this fall. It's by the same guy that did Corpse Bride and everything. The world is coming to an end, and the last living scientist has created 9 entities which are going to be the trustees to protect the world until the people return to the world. What are they telling you? It's reality. It's not science fiction. It's not Hollywood fantasy. 9 is the judgment. Doesn't the judgment always come down for the creditor? So if you're in court, why are you upset about the judgment coming down? If you were the creditor with authority, where is your fear? The only reason you're afraid is you go into that court in the role of the debtor, and you know it's not going to be good because that's who you believe you are. Now, haven't they just done a bailout? But the bailout was in the republic or the democracy? Democracy, okay? Didn't Bush come out in September and say we got a liquidity crisis? What does liquidity crisis mean? Does that mean we have too much circulating money or too little?
Too little.
Too little. Why did he come out? First he said we got a liquidity crisis, and he talked about something almost implying that the people of the United States had a problem. It was like he looked at us like we were debtors. Then he came out a week or two later and he said liquidity crisis, but we have to create more funding. If you're creating something, aren't you a creator or a creditor? Now, in their system, what circulates as a money? Asset or liability?
Liability.
Liability. So, what did most of the people yell and scream? Oh my God, they're going to print money. We're all going to be up in debt to our eyebrows. Our grandchildren are going to be in debt. How do you create money in their banks? Borrow it into existence. If you borrow it, aren't you going into debt? So in order to create money, you've got to go into debt. He said there's a liquidity crisis, so how do we cure that? We all go out and we take on 20 times as much debt as we had. That'll cure the liquidity crisis because it'll 20 times more money. But people are going, why, that's weird. Why would I take on debt if there's no money circulating? I can't pay it. Because if you don't take on debt, that's why money ain't circulating, and that's why you can't pay it. So you got to go out and create debt. So how many of the people went rushing out to create more debt? Nobody. They said that's asinine. But that's what happens in their world. Their world's upside down. It's all ass backwards. It's dysfunctional. So the president said, well, if you people aren't going to save us, what happened in the House? Didn't the House put in a bill for bailout? Doesn't the Constitution say all money bills have to originate in the House? Who was the House supposed to represent? The people. But they said that 20-1, all the communications with the House of Representatives by the people were saying, don't do this. Okay? The House voted it down. They followed the people. Do you guys all want to sit at home? No money, no ability to pay your bills, can't purchase food, can't purchase energy. You're going to die. Who came to your rescue? The Senate. Who does the Senate represent? The corporate states. Did the Senate pass the bailout bill? So who came to your salvation? The people or the corporate states? Then who's the creditor? The people or the corporate states? Corporate states. You people are acting like wards of the state. They were responsible as creditors, and the people were irresponsible. Do you have any clue as to why everything in the world is treating you people as debtor slaves? Because that's the way you act. Your actions are more important than your words. You act like irresponsible debtors. The fictions have to come and save your ass. What should you have done? Well, look at it this way. Where did the bailout money go? Who got it? The banks. Look at block 4. Below the line is a commercial voyage of the good ship USS United States. And the grantors for that commercial venture is the banking system. Who has the most authority in any trust? The grantor, the trustee, or the beneficiary? The grantor. That's the source of the ultimate power and authority. The grantors pick and choose and empower the trustees. Now, if the banking system on the public side is the grantor to this corporate government venture, which really is not government at all, then the trustees are the lawyers, the attorneys, the elected and appointed government officials, and the officers of all the corporations that were created by the government. Isn't your straw man a corporation? And aren't you supposedly running the affairs of your straw man corporation? So aren't you presumed to be a U.S. official trustee? Are you free to do anything that you want as a U.S. trustee? Or are you subject to their statutes, their legislation, their rules? Absolutely. You're in that jurisdiction. Now, isn't the so-called purpose of all corporate enterprise and or government enterprise for the purpose of helping some beneficiaries? If you want to go back to the presumption of the starting of the nation, isn't that supposed to be we the people, beneficiaries? Or let's put it in purely commercial terms. Who are the beneficiaries of a corporation? Stockholders. So isn't Block 6 our straw man corporation, who is a stockholder in the corporate state venture and a stockholder in the federal national venture? And don't we each get our fair share according to our stock ownership in that corporation? So you're seeing an outline of exactly the dual trust system, the private and the public, one a mirror image of the other. And when it came to bailing out the commercial corporation below this line, all the money went from our trust accounts, and by our, I'm saying the living men and women's trust accounts. And didn't it get transferred to the banking system that was basically financing all of the activity of the state and federal corporations, including the private corporations like GM and Chrysler underneath the head corporation of the United States? Why shouldn't the grantors in Block 4 be shifting some of the funds to those other corporations like GM and Chrysler? After all, we're just on a giant venture on the SS Titanic, hoping that Chrysler and GM can keep up productivity so the passengers on this venture will have toys to run around the decks on the ship as we go through the sail. And since we're all on the vessel and we're all there, one relating to the other, each trying to help each other out, just to have a safe and an interesting and a prosperous venture, why shouldn't we just rearrange all the assets in this public trust? if we have some sick passengers, why don't we put up a fund so that we're on the vessel, everybody's going to get their health care treated on this vessel? Aren't we being told we're going through a paradigm shift? Isn't the cat out of the bag? We're not on the land. You're not in it for yourself. When you're on the boat, if you get sick or your neighbor gets sick, it affects you because you're on the vessel. And we got to make sure that we don't have an epidemic on this vessel caused by the people in the lower decks not having health care. It's going to affect the voyage, and it's going to interface you. These people are telling you the pattern of what you're looking at. Are you ready to play that role, or are you ready to leave this trust below this line? Understand that you are a part of that trust above this line, and go back home to Kansas again, because you're going to resolve all those problems as it applies to you in that public trust. Now, what you're seeing on this diagram is that birth certificate, first of all, got registered in the public sector, which was below that line, correct? Wasn't one of the first things that we were told we needed to do is an acceptance on that sucker? And we needed to put in a UCC 1 notice of filing, which constitutes a lien, or notice of lien. What we were essentially doing is saying, hey, buddy, I want control over whatever the collateral in that trust, based on that birth certificate security filing, gives me a right to, and I want to pull that above the line back up into the private. Instead of assume that I've agreed to be a trustee down in Block 5, I want to get back and play the role as the trustee in Block 2. So by the acceptance in the UCC 1 filing that many of us did 9 years ago, and many of you are looking at now, what we're doing is we're changing the situs of the control of that trust corpus from below the line in the public sector to above the line again. But all of the assets of that trust, the equity, are not yours to use. All you're going to be, if you are able to deal with it, is to take control over that by operating Block 2. But you're not going to die and take those assets into the grave by burying some kind of truckload of TVs next to you. It isn't going to do you any good. So as long as you're alive, the best thing you can do is control that trust, but claim no ownership in that trust, because an ownership is a debtor side, has no control. A control side has legal title and does have control. Rockefeller said, the secret of life: control everything, own nothing. The world's wealthiest people are on a list. Where is Rothschild and Rockefeller on that list? They're not on that list, because that's for owners, and they don't own anything. If you're on that list, you are nothing more than a massive debtor, because the more assets you accumulate, the larger liabilities you possess. What do you think the Lord said in the New Testament to the rich young man who came to him and said, what do I need to do to be saved? The Lord explained what he was into, and the Bible says he walked away sad. Look, you only walk away sad when you know you're wrong and you won't straighten out. The Lord probably said, hey, look, you own a lot of crap, but you're the biggest debtor on the block. and you got no legal title for anything, and the only reason you accumulated that wealth is because you kiss up to the emperor. And when he decides you're out of there, your wealth is gone. The advice was sell ownership, contribute to the poor, and go out and lay up your treasures in heaven by control. Stop playing that game. You're not winning. You only think you're winning. Let's use this chart for a minute. You see I got three things on the line. Haven't I got the FRB, Federal Reserve Bank, the DTC, Depository Trust Company, and the IRS, the Internal Revenue Service? There is a private side to each one of those entities, which deals above the line. There is a public side, which deals with the public below that line. All three of those entities are private international law organizations. They're not government at all. Every one of those organizations are under the Secretary of Treasury, U.S., as his agents, to help settle the matters between the republic and the democracy. Why doesn't the government in public ever acknowledge anything that's going on above this line? They will never acknowledge it. Why is that true? The first 13th article in amendment said what? No titles of nobility. Is a democracy a military-run government? Yes, a military oversight government with drapings of civil authority. Is there titles of nobility and ranks in the military? Okay, so under the first 13th article and amendment, which was passed in the United States of America in the early 1800s, it said that we could not have titles of nobility in public government. What did they do to get around that? They changed the public government from a republic to a democracy. Can we have titles of nobility in a military? So what they did is they changed the style of the public government from republic to democracy in the Civil War. Therefore, the titles of nobility could now operate in the public government. Did they take away from you the republic? No. They just moved it from operation under public government to private. Do you still have your remedies, unalienable rights, and everything else you're entitled to? Yes. Where do you have to go to assert those? To the private side. You cannot assert them in public. If you go into a public traffic court and say, I am here to assert my unalienable right to travel, what just happened? What are they going to say? In this court, in the democracy military, there are no unalienable rights because the public has now gone to military. Does that mean you don't have them? No, it means that you cannot bring them into the public side of this court because the public side cannot recognize them. If they did acknowledge and recognize them, what would happen to the judge and the attorneys? They'd be in treason and they'd have to go hang themselves. So they're not about to do that, so they won't go to where you want to lead them. So if you want an unalienable right in their public courts, where do you have to bring your record and evidence? To the private side of those public courts. Where is the private side of those public courts?
Chambers.
In chambers. If you're trying to file your evidence record of an unalienable right with the clerk's office in the public courts, they will file them in there and they will pronounce firmly, we're denying your rights, because you don't have those unalienable rights in the military democracy government. But if you were to slip them in the back door privately, and you had the proper process, and you were in honor, and you didn't get in an argument with the public court under public policy, you might just get the judge to recognize in chambers that you've settled and resolved the matter under unalienable rights. In the democracy, rights are inalienable, or in an alien state. If it's in an alien state, can it be denied? You bet. But if it's un or not alienable, if it's in a lien, that's another way of saying it, state, can they lien it? Yeah. So by changing one letter in the word from un to in, you went from unalienable rights above the line to an alienable state below the line, and they've liened it and denied it, because you're coming in as the debtor below the line instead of the creditor above the line. This all goes back to authority. Who is giving who authority? And if you are below the party above you that granted you something, you're the debtor, you're not the creditor. Look at all your criminal and civil cases, and then we'll go back over again to what Brandon's doing. Let's use this roadmap to show you what's going on. Where does every case start and settle? Above the line or below the line? Above the line is where the authority comes from. Who finances the grantor in Block 4? Does it come from below the line, or does the finance come from above the line? So who's got the authority? We do, above. Okay, if you truly believe that your straw man is the beneficiary of this so-called government in Block 6, you're a debtor, right? How the hell did that debtor get any benefits? Where'd they come from? Above the line. And what block had particularly created those benefits above the line? Block 1. Because everything he had was sent to Block 2 and then loaned to Block 3, which made grants to Block 4. So if everything your straw man is getting in Block 6 as a benefit, who the hell provided that benefit? You did in Block 1. Let me ask you a question. Are you the creditor or are you the debtor? If you're the creditor, why are you worried when President Bush said, we got a liquidity crisis, let the straw man execute more debt? Because where is he borrowing it from? Us. We're the creditor. They owe it back to us. Well, you people all crazy? You don't know this? You guys all want to go down the commercial suicide chute by having your nation basically shut down? I drive around now. There's stores that are closed. There's shopping centers that are empty. There's people living on the street because they don't know they're the creditor. They are so confused. They're worried about passing on a debt to who? What, do you think their children are fictions under 6? Or are they the creditors of an account which, when they're 18, they should be able to collect on? You see, they got you looking so upside down, you have no clue who you are. And because you have no clue of who you are, collectively as a nation, we're shooting ourselves in the foot and going down the tubes. So that the government's going to come and rescue us? Look, if you're not smart enough to create authority of debt at 1 to bring us out of these financial doldrums, what do you think the corporations under Box 5 are going to be producing to bring you out of anything? Aren't they shutting down too? Why are you guys all going into the grave? There's a country western song. I love it. God is great. Beer is good. People are crazy. You guys are all lunatics. You have no clue. If you're in a civil or a criminal court, why has your straw man been charged into the court? What was the problem? Because the guy in box 1 and box 2 didn't do his job. Who is that? Is that you or is that the government? That's you. Okay? Box 1, if they below the line could look up and see Dorothy, box 1 would be the lion. He would be the natural living entity which is supposed to give his corporate operation some guidance. Box 2 is the banker creditor. He's the trustee with legal title, which means he's the banker with the credit for the corporation. That's the Tin Man, okay? Now, box 1 has no number. Box 2, basically the banker, he has a number, and that particular number is the EIN number. An employer is a creditor, an employee is a debtor. Box number 6 is the scarecrow, the straw man. He's the debtor side of the corporation. He's the one that benefits and brings in all the receivables. But remember, the scarecrow's lacking a brain. He doesn't know what he's doing, why he's down there, and what he should do. Isn't the scarecrow trying to pay off the debts for everything he receives? He's a scarecrow. He's a debtor. How the hell is he going to pay off his debts? Isn't he below the line? So he's a liability. Jurisdiction. He has no assets. If he has a bank account, it's filled with IOUs and debts. The more he takes in, the higher the IOUs and debts he's got in his bank account. I don't know why anyone would go rob a bank. All they've got is more debt. The more you rob, the more liability you're taking on. What kind of logic is that? People are crazy. Well, the reason that the guy in box 6 is being sued civilly or criminally is he's in dishonor and contempt for not having paid an account. Why should that surprise us? He can't pay an account. He should be going to the Tin Man to get the account paid off. But you see, the lion operating this corporation is too shy and lacks courage to do it right. So the grantor in box 1, the lion, does not kick the Tin Man in the butt and tell him to go out and pay the account. And the scarecrow down in box 6, he's so stupid he tries to pay the account with liability, runs out of funds because of the liquidity crisis in that society, and thereby gets into trouble. He's in dishonor for not settling the account, and he's in civil or criminal court. Who should be rectifying this problem? Box 1, grantor, and box 2, trustee. The trustee should take care of it. If the trustee does not officiate and take care of the business of the trust, what does the commercial system think is going on there? A corporation that will not or cannot or does not pay its bills is presumed to be what? Dishonorable, but insolvent. Or, if you want to put it in terms of a fiction, didn't it just go sine die? What is sine die? It ceases to exist because it's not meeting its obligations. Well then, if block 1 and block 2 in terms of commerce and law doesn't exist, didn't it just die? What do you do to settle the accounts of the dead? You go into probate. So all of the civil and criminal cases in all of the public courts of the land are probate courts. They're just probating a death in commerce. That's all they're doing. And if you come into that court to give testimony, what does the judge do to your appearance? Ignores you. You're dead. You're not here. We can't hear you. And so the facts are on the moon. Why are you at the probate court? They're probating your death. What logical sense does that make? Well, how are they able to do this? Fiction of law. If you're not there, but the corporation has ongoing commercial transactions that aren't settled, does the law provide a remedy for that? No, because if you aren't there, you can't settle it. So we got to settle it in equity then, in probate, don't we? So what do they do in probate? They create the fiction that the trust that had existed in reality and is now sine die and dead will create a mirror image of that trust down in our land for the purpose of winding up the affairs. And as soon as this mirror image trust in the public winds up the affairs, then we'll dissolve it too. So that we formulate a remedy in equity so that all the parties that are owed some commercial settlement will get their settlement before we terminate the probate. So whereas you, the living grantor in Block 1, are now presumed commercially dead, they mirror image you as the grantor in Block 1 into Block 4. Who's the grantor in the parallel trust? The judge is the grantor in the court case, which is a probate of the fact that your trust is deceased. Does the grantor have some power, all the power, as much as he needs, or is he restricted? All the power. Is that the judges that you've run up against in your court cases? Do they seem to be much restricted in anything they're trying to do to settle the case? No. So, because you died, because you lacked courage and abandoned your position, you empowered the judge to be as you with all of your power. And you're not there. And you can't be there. Now, with all of your power, what did he do to settle the case? He appointed his trustees, attorneys. Where did the authority of those attorneys come from? The grantor judge. Where is your authority to fire them? You don't have any. You're not there. If you try to fire them, it's just more insanity. You're trying to show up as a ghost, and they're not recognizing you. But it's odd because you're the ghost from reality appearing in the land of fiction, and fiction won't recognize you as even a ghost from reality. So the trustees are there empowered by the judge to do what? Argue? Just settle the affairs. How do they settle affairs? They gather the assets of the trust, and if they need to, they liquidate the assets. Do they need your permission? You're not there. Who gave them permission? The judge. Where was his authority? Came from you when you died. Are you beginning to understand? Government isn't doing anything wrong. From the authority, where is their authority coming from? From you in Block 1, 2 all the time. And you're not there. which is why you are empowering these people over you. Because you're not accepting and settling the matter. You have to recognize you have been given the authority from the Creator God, and we have abandoned our authority, and we've given it over to the servants who have gladly taken it away from us because of our total incompetence. Authority is one of the key factors that you have to understand. I send back to the floor.
All righty. Oh, am I on? Yeah. Okay. We're going to take our one more break.
It's necessary for a procedural and substantive remedy thereto.
Wanted to start on next is going over the elements and the principles of establishing a claim through a process so that when you leave here, see, I could just put up a bunch of example documents on the screen, and on the CD you got, there's probably about 1,000 examples from all different types of sources. Now, most importantly, you must come to an understanding before you go putting your name on any process and using it. And you've got a plethora of examples to choose from. I would suggest using them as learning materials and using your knowledge of how to structure claims and processes to build your own. There's nothing more empowering than creating your own process. I mean, I love it. When I come up with a new document, as a part of my process, that I'm like, yes, I've created something that in my view and my understanding achieves something. And of course, I put it into a process. But it's very rewarding and the best teaching. Now, what I use, like the materials that you have on the discs, I use those as reading materials. When I hear a phrase that someone else has used in their commercial documents, I'm like, oh, that's perfect. It says exactly what I want to say in this part of my document. So you can use bits and pieces of everyone's process. Now, you have to make sure that it all lines up so that if it is a private process from a non-domestic source, that you're not confusing and sending it through certified mail. You must understand these principles so that if you're doing it from the private side, you understand how to keep it private and on the private side. If you're doing it through a notary, understanding the limitations and what you can do with the notary and the advantages. Okay, so a process or a claim can be established via a process. Now, we've talked about due process and administrative procedures in our classroom sessions. So those of you who actually download, listen to the classroom sessions, things like that, you know what we're talking about when we say due process and administrative procedures. But here's the basics. You make an offer or a demand. You follow it up with a notice of fault opportunity to cure. That's part of the due process. Maybe it was an oversight that you did not meet the demand met in this, or that you did not respond to the affidavit with another affidavit, followed up with a fault or default. When you have all three of those elements, you've now created an agreement, facts, from which now gives you a claim, an interest in, a title to something. You want to read your example of, or yeah, go ahead.
We're talking about claims and administrative process, how to get your way, etc. It's how you, well, what is a claim? A claim is defined, or one of its definitions is to demand or ask for as rightfully belonging or due to one. Rightfully belonging or due to one. Well, how do you get something to rightfully belong to you? Because you say it is? Ladies and gentlemen, New World Order is here. It's called contract law. You're not this guy. I think I heard Bush say something, what, this so-and-so document, the Constitution? He's got a good point. What's the Constitution got to do with any of you? Did any of you sign it? Were you a party to that contract? The states were. People that have constitutional rights, I don't have any constitutional rights. I have constitutional protections and guarantees. Like the Second Amendment, the right of the people to keep and bear arms shall not be infringed. That's an order to the federal government. Federal, of or by compact. We're talking about your claim. How do you get a claim? How do you establish a claim? What's your administrative procedure? A 1, 2, 3 process. It's the law of the land. What is law of the land? Blacks. Is most clearly intended the general law, which hears before it condemns, which proceeds upon inquiry, and renders judgment only after trial. 3-part process. That's the law of the land. Some of our churches may teach, our churches, some of the churches may teach the law of the land is the laws. The laws, the contracts, that's what you're saying, the contracts? Which contracts? There's only billions of contracts. Which ones are you subject to? Whichever ones you agree to. But to get your claim, let's get to it. How difficult is this going to be to learn? Not very difficult. And let me give you an example. I have a sister who runs a Firestone Tire Care Center down in San Diego. And she was having problems with the phone company that was slamming the phone bill at her place, $49 a month. And she said, brother, what do I do about this? I said, let me handle it. She says, okay. And I said, well, before I do that, I need you to know what I'm doing. So I gave her a little article about administrative notices, what they are, or the first step in what we call our administrative procedure. You know who's good with these administrative or contract laws? Your favorite people. Should be your IRS. The IRS. They send you a little notice. What do you do with it? What's the average person do with the first letter? You owe some money. $1 billion, $100,000, $10. What difference does it make? It's a commercial presentment. Most people just say, oh my gosh, and they just, put it in the drawer and there it sits. Along comes the second one. What do they do with that one? Hide that one away. And there comes the third one, and pretty soon, not too long after that, there's a notice of levy or a lien on the bank account, or they took the money out or whatever. Do they have a right to do that? Were you taken to court? No? How about this for a great one? In common parlance, going to court is synonymous with going to trial. What that means is that each of you, in common parlance, everybody thinks that going to court's going to trial is the same thing going down to see the black robe guy sitting up on the bar. No, it isn't. Court is, one of the definitions of court's really good. The residence of a sovereign. A sovereign, the resident, wherever authority is. Are you not authority? You're in court. What court is that? The court you're holding. The IRS is holding court with you. had a certain large retailer and a certain warden and a certain other people. We went to court. I started sending my little notices. Hi, how are you? I call it my hi, how are you? My sister says, she reads the article, this little administrative, so she can kind of know what administrative notices are. And she says, let me do it, bro. I said, no, let me do it. She says, let me just try it. I says, okay. So here's a layman's put together on somebody that slammed her phone account at the company. And my sister's real conscious about it's her store, she cares about the company, and a real super neat manager. So she put this highly technical deal together. So, my name is Margaret Ferris, and I am store manager of Firestone. I called you last month in February of 2009 because there was a charge for $49 on my bill from you that I did not authorize. That's pretty technical. You billed me again on my statement for March 22nd, 2008, and I want you to stop billing me for this and credit me $49 on my bill. Stop doing this and give me my money back. The person you said authorized this has not worked here for years, and this leads me to believe you have committed fraud. She didn't accuse her brother. She said, what do you think? Could this be fraud? That's how technical step one was for her. What's miraculous is to watch what people write back. Because what Brandon, Jack, the rest of us will tell you, it is not what they say, but what they do. And it's so confusing to the layman's mind, it's almost incomprehensible. Here's what they wrote back. Now remember, the person that they said had authorized this hasn't worked at that place in years. But that doesn't keep them from alleging it. On January 1 at so-and-so time, we contacted your company regarding this service. The service was explained in detail, and authorization was given for the $49 monthly fee to be applied to your telephone account. We use a verification department that verifies authorization of this service, and the conversation is recorded for your protection. Wow, that's pretty affirmative statement. On January so-and-so date, we spoke with that individual, call him John Smith, who stated that she was authorized on the account. However, due to the fact that the registrant is not authorized on your account, the registrant, what the heck? The account has been canceled per your request on X date, and we have issued 2 credits in the amount of $99 and change, plus any taxes that you may have been charged. Please be advised this can take 2 to 3 billing cycles for the credit to appear on your telephone account. She just wanted the $49 back, and they found it in their heart to not only give the $49 back, but treble damages. Kind of nice. That's an administrative notice. Had one of my associates got a bill the other day from one of my students got a bill from Visa, and it said, you borrowed this money, you owe this money, boom, boom, boom. That's an administrative notice. Then they sent the same exact identical notice, only with the date changed like 45 days later. So they just sent me the same letter. Yeah, second notice. It wasn't entitled Notice of Fault, Opportunity to Cure. It doesn't have to be. You got a second notice. These are not overly complicated. All you need is a few examples, but believe it or not, your remedy is not that difficult. Once you've seen a few of these, and like Brandon says, you grab a little language from that one, you see that one. Where do you get a bunch of administrative notices that are pretty sharp? IRS, that's who. They got great ones.
And they even put titles on them. Why you're getting this notice, what you need to do, what happens if you don't. Those are their subtitles.
Same thing. When I had a certain person that wanted to buy a chess set, I says, hey, it's my private property. People under your supervision took it. If you'd like to keep it, it's $40K. Send him a second one. Brother, are you sure you want to keep that thing? It's going to be 40 grand. And if you don't pay it, it may subject you to a lien, a commercial lien. Of course, he didn't mind. He thought he wanted to keep it, so he kept it. Pretty soon he had a lien. And things really got fun after that. So there's so much you can do. And the word may is really a unique word. You think you know what may means until you get blacks to get you a little bit about what may means. I might read this to you. Let me read in pertinent part. Regardless of the instrument, however, whether constitution, statute, deed, contract, or wherever, courts not infrequently construe may as shall or must. May it please the court if I enter the bar under said terms and conditions. It may subject you to a lien. May? I just told him it's gonna. Can't help it if he doesn't understand what may means. You can't help it if you don't know what the judge means when he says, who are you? He asked you, what are you? What are you? What are you? Are you an artificial person or a natural person? Well, I'm not a person at all. Well, depending on the context. Natural person has a reference in law to you, as opposed to an artificial person. Well, I thought person was an actor's face mask. Language is a difficult thing to grasp. Context is everything, ladies and gentlemen. But it'll come to you if you'll do some study. So, for your administrative remedy, you're going to start learning to do step one. What did the scriptures tell you? If you've got a problem, they didn't say go file an action in the court. It said go to your brother. Brother. People under your supervision took my chess set. Or major retailer, brother. I offered the people that at your company for failure, for compelling me to, or attempting to compel disclosure of the Social Security number, that for violating 5 U.S.C. and 552A and 408A8 and 42 U.S.C. 1983 and giving them some quotes, they've obligated themselves to $10,000 penalty. Of course, it didn't keep me from going and cashing that check at the other retail store where I gotten it. So where's my damages? Damages happened right then and there. They made an agreement, not my problem. The employee, the supervisor, the store manager, and the district manager all agreed. For violating my rights and United States laws, it's $10,000. So your first little notice is nothing more than a, hello, how are you? You owe me, I think. Or leads me to believe you're committing fraud, so you'll find plenty of examples. And you give the appropriate time and allow some of your brother to come back to you. Now, why wouldn't you send them a second notice? Brother, in case it was a mistake, error, or fault, I haven't heard from you. And here's a copy of the first notice. Please get back with me. Maybe you missed it or it didn't get to you or something else. Of course, I sent a certified mail, so I know they got it. But hey, don't you care? Do you want someone just to slam a lien on your butt? No, I like them to come and talk to me. That's very civil. Now, after the second time, it looks like we've got an agreement. I need to let you know you got a judgment against you. And you'll probably be silent about that one, too. Now, that got my private side done. Not too difficult. Now, I'd like to make it public because, you know, really, if you're going to be dishonorable in the commercial world, maybe it should be reported on your credit report in a few things. Maybe I could result, it may result in a lien being filed at the Secretary of State's office, UCC division. May? Wow. I'd pay attention if somebody said something may happen to you. Especially now that we know what may means. Something's going to happen to you. Next time IRS says something, it may subject you to penalties, including prison time and this and that. They didn't threaten you. No, they told you exactly what's going to happen. There's no threat. That's a promise. An assurance. Welcome to the real world. A man only begins to be a man when he ceases to whine and revile and commences to search for the hidden justice which regulates his life. What regulates your life? What? Maybe it's easier to ask you who regulates your life. Yourself. There you go. We've seen the enemy, it is us. We are our own worst enemy. I'm telling you, this government is the best it's a perfect government. People say, oh, perfect can't be perfect. Well, it depends on what you think the word perfect means. One of its definitions is not only flawless, which this is not a flawless government, but another definition is complete or whole. It is complete. It is whole. The republic, democracy. It's perfect. And what did God tell you? Be ye therefore perfect, even as your Father in heaven is. Oh, I can't be perfect. He didn't tell you to be flawless. He told you to be whole and complete. I like Webster's definition of conscious. Webster's defines conscious as awake to one's surroundings and identity. That's a very interesting definition. Awake to one's surroundings. I thought conscious just mean awake and not asleep kind of a thing. A layman's understanding. But if Webster's defines it as not only awake to one's surroundings, could it possibly be an identity? Why would being conscious be awake to your identity? You need some study. This is going to be a lot of fun for you. 3-step process in this. A UCC file. What's a UCC? Nothing but evidence of a lien. But what's a lien? Isn't it a claim on the property of another as security for the payment of a just debt? Just debt? Sounds like there was some justice and fairness to get that just debt. Yeah, you better be doing proper process. If you owe me something, it's not fair if I just go slap a lien in the public registry against you. That's not right. I haven't given you due process, have I? It's not the law of the land. So as this gets explained to you, look forward to that it's that easy. It truly is. Another interesting story that helps you to get that, to going to your brother. I was in a prison, and one of the guys said, oh, I sold a piece of property. Can we fix this?
Yeah, it's because you're not, your microphone's pointed out there.
All right.
And it's hard for him to pick up your voice.
Let's try that. Is that better? Yes. Excuse me. Had this young gentleman, he's doing 20 years. He's 2 years into his sentence. He had sold a piece of property for like $500,000. The person put like $250,000 down, made payments, but yet owed 4 payments of $19,000 apiece. Came to me and says, Gordon, can you help me collect? Can I get a lien against this guy? I said, sure. But I said, you need to do some due process. So we made out, hello, how are you? Brother, I sold you a piece of property on or about this date. You put this much down, etc. A relation of the facts. I haven't received the payments. Sister says, I haven't got them. That's what his sister was telling him. She hadn't gotten them. We sent it off certified mail. Pretty soon, we got an answer back from him, along with four checks that had been cashed. Guess whose signature was on the back of them? His sister's. So what if he'd have gone and slapped a lien on that guy? He did due process. He went to his brother. Brother, you haven't paid me. Hey, why would he need the money? Sis says, he's going to be 20 years in prison. He doesn't need it. I'll do what's best for him. I could use it. Woo! Nothing like family. Nothing like friends. Of course, God did say don't put your trust in the arm of flesh, but hey, you want to keep doing what you're not supposed to. That doesn't mean you distrust your brother. That doesn't mean you distrust your brother or some other fashion. You trust him so far. Don't give him your life. Don't put your head in a noose just to show him so that you have some excuse for your own failure. Doesn't mean we run around distrusting. But you're going to love this administrative process. It's easy to learn because it is kind of that simple. My sister is just a high school graduate. I want you to stop doing this. I was pretty technical. You know. But I tell you, that little statement, this leads me to believe you're committing fraud. That's a bad statement. Because what happens if they keep that and ignore it or fight? They've agreed they're committing fraud. Whoa. That's why whenever you get anything, you're in court, ladies and gentlemen. Welcome to the real world. Quit whining and reviling and start searching for the hidden justice which regulates your life. Hidden justice. You're in court. What a beautiful thing. When you finally end up in a public court or federal district court, that's your first appellate court. What can be seen in the appellate court? Some of you are not sure, but if you do an appeal from a lower court, the only thing that can be brought in there is the existing court record from underneath. Guess what I have? Now, in that particular warden, he went to a federal district court to try to get the lien off. Federal district court said, we have no authority over the commercial code of the state. They said, we have no authority over contracts. Matter of fact, the Constitution, which secures and guarantees my rights, my God-given unalienable rights, in Article 1, Section 10, Clause 1, states in pertinent part, no state shall pass any law impairing the obligation of contracts. I had a contract with that warden. Federal District Court honored that. And then it got even better after that, because somebody decided that maybe they should put something on Department of Letterhead Justice Stationery that says, you either take that, you don't have a right to do this, you don't do that. Lots of beautiful arguments. You're an inmate, you can't do this, you can't do that, and if you don't take it off, I'm going to seek civil or criminal penalties. Oh my gosh. Sound like a threat to me. So I just had a question for the Federal District Court. Why shouldn't be arrested and removed from office? Just question. I mean, I don't want to say anything. Just, what do you think? Well, I'm sure they took that hot potato. I gave it to the judge, and he gave it over to probably some warden who probably went in there and said, but, door 3 or door 4. Somebody got arrested and somebody got removed from office. Wow, is that a thrill? It was the best. I'm telling you, this stuff is like gold. All of you that have problems, if your heart's in the right place, you're going to get remedy on everything. To you all that have tickets, to you all that have other commercial presentments, this is commercial law. Contracts are dynamic. They move. Care what you decided yesterday, let's do something else today. This is what you're here, getting this language. 3-part step on the administrative remedy, a couple more things, boom, you're in business. It's going to be that easy. So as soon as you start, like my sister, she didn't even want me to write it. I said, yeah, let me write it. I had another situation where my ex married this really neat financial planner guy. And they had like five offices. And this guy is just a sweetheart of a guy, but he's got a partner in, too cool. Makes him do all the work, this and that. And the long and the short is that the partner that has some personal problems decides to lock him out of his office and shut the computers and take a pretty sizable amount of money out of their partnership fund. And so it took him about 2 weeks before he'd let me handle a little letter for him. I said, oh, please let me do my hello, how are you to him. And I had to finally go to the ex and say, come on, Stacy, please, just tell him to let me do it. Because this guy's so nice. He's just the nicest guy. He's just non-confrontational. Take 6 figures from him, take all the office, and he just go away and start something else. Don't do that. Don't let that happen. It's wrong to let that happen. You're not, I always like spare the rod, spoil the child. Well, spare the rod, spoil the corporations, the way I see it. So we wrote him a little letter, and he had about as erroneous a letter to him. So I recognized that this guy that locked him out and this and that said, oh, Keith, you need to come in here, and so you didn't make it, and I don't know what your problem is, and I've done nothing to affect you making money or any of it. I mean, just blatant stuff. I'm not locked you out of the offices. So I did a conditional acceptance upon proof of claim. You didn't change the locks, didn't give me a key, and still not refusing to give a key, and et cetera, et cetera, et cetera, and a couple more little things. and then a real wonderful one that your actions have not in fact caused $1 million in damages. Whoever he gave that letter to, pretty soon this guy's calling Keith back 6 to 8 times the next day. Keith walks with 4 officers, guy, give him everything, he didn't want anything to do. He says that letter was a weapon of mass destruction. And it was. He took all those partnership monies and put them in a personal account. He's mine. Party's over. Damage is done. You better be doing the right thing out there, ladies and gentlemen. Because when people put this stuff on you or vice versa, unless you know what you're doing, it can be a bad day. That's why I said if you're my neighbor and I don't like you and I'm like an idiot, I might say I've been watching the neighborhood for a year. And that's bad. That's wrong. And of course, cause and effect rules the universe. So I'm praying that you have your heart in the right place. Because this is not to go out and damage people with. This is what's the purpose of law, if not to bring harmony? That's the purpose of law. That's the purpose of contracts, to bring us into harmony. So you want to come at this with a good heart. How do you want to be treated? Because how you treat is how you're going to be treated. And rest assured, I'm under God, so I know He's going to see to it that things go down the way I do for others. So I'm not interested in helping bang people, hurt them. But in some cases, I take a little umbrage over certain things. I knew that probably 2,000 Firestone stores got a bill for $49. And I know there's at least half those managers just, what is this? The company probably put it on there something. Nice deal. But this is business. Welcome to the world of man. So as these fine gentlemen, us, we get you tuned up on this and you learn it, you're gonna love what you're gonna learn. You're gonna be like powerhouses. But you should be kind and loving. You love your brother. What are you doing this for? Get under God and watch how these epiphanies come to you on doing these things. It's important. Not interested in hurting wardens or hurting somebody or a big retailer. And in many of these cases, there was a nice compromise met. I'm not interested in hurting them. I'm only interested in helping them. Not interested in taking their money and bankrupting them or getting even or revenge. I don't think I'm going to be allowed certain things without that. Cause and effect rules. Remember that. Keep it.
All right, I think something important, let's identify the necessary elements of a claim as in the claims that were just presented there. I think there's at least 3 necessary elements. A cause of action. I got billed $49 erroneously or fraudulently. Damages, $49. Liability. You're liable for fixing this, or for paying me the money you've taken, or for compensating me for the damages. I'm sure you've heard about people going into court trying to get their remedy and the judge coming back at them with something to the effect of, you failed to state a claim upon which relief can be granted. They did not have all the elements. Cause of action, liability, and damages. Go ahead.
Excuse me. Court. When you're in court, and this is a thing, we talked about what law is contracts. You're either, when you go into a federal district court, a state court, it's a claims court. What he's talking to you about is establishing a claim. If you have a claim or a contract with somebody, you do your 3-part, you now have an agreement, right? You have a contract. That puts you in a law court. If you're not in a law court, you're in what I refer to as an equity court, which is defined as a system of rules and doctrines, as in the United States, supplementing and superseding common and statute law whenever it proves inadequate for just settlement. You're not under the common law, none of that stuff. It's all contract law. If you go in there without a contract, you're failing to state a claim upon which relief can be granted. Because a claim is the demand, or ask for is rightfully belonging or due to you. There's a great poem I like from 1840. So this stuff isn't new. This isn't some new thing. Law doesn't change. Contracts don't change. So every time you hear the word law in this poem, think contract. Once law was sitting on the bench, and mercy knelt a-weeping. Clear out, he cried, disordered wench, nor come before me creeping. Upon your knees if you appear, 'tis clear you have no standing here. Then justice came, his honor cried, your status, devil sees you. Amicus curiae, she replied, friend of court, so please you. Begone, he shouted, there's the door. I never saw your face before. What Brandon's simply telling you, this cause of action is your, the facts stated, what it done, etc. Get your contract. You can stay on the private side. You don't even need to go to the public court, but there comes a time when you do need to go to the public court because we've talked about it. Is it not true? This is from Jack, because I was doing Jack, we want to talk real quick about, is there not both a public and a private trust that run parallel in today's society? Is it not true that the public has not the resources to resolve all problems in private? Yeah, they can't fix everything. Is it not true that the only reason public trustees are involved in any problems is because the private parties fail to resolve it? Right? So the only time that police, judges, and all this come into play, or with us in the IRS, is because the problem's not resolved. You have the horsepower with the administrative process to resolve everything before you ever go to court, as a layman calls it. You've been to court. When we go to court, guess what the IRS puts in on the administrative remedy on the private side that goes back, that's not out front? IRS files a suit against you. You go in there and do what? Not guilty, didn't do it. And you argue and fight, and the judge takes a look at the lower record. What did you respond to? Well, if I get an indictment from them, it's going to be based on some administrative record. So if they send me stuff, I'm going to always write back. And then I'll have an administrative remedy. I'm happy to come in. I've got a couple students right now that are doing some really interesting things, and they're finding themselves in a federal district court on indictments and various other things, and we're doing pretty good. One of them got served and summoned to come in and be arraigned. And we conditionally accepted the offer to come in and be arraigned upon condition that, and now they had done their administrative remedy already, upon condition that any determination shall be in accordance with the record and pleadings of the parties, which is accepted, that has set off and settled and closed the matter. So we put in the administrative remedy on our, remember, they gave us a commercial offer. So when you want to come on in and argue about this, I'd love to, in accordance with the administrative remedy, in accordance with the record and pleadings. That's what I'm willing to do. So great, as long as you rule in accordance with the record and pleadings, and that's how we got it in. It's very magical. It's just business. Once you get all these processes down that Brandon, Jack, and myself are going to be teaching you, you're going to get good. And you're going to be so much at ease about this world, this confusion, this pandemonium. Milton's Paradise Lost. What was the capital of hell? Pandemonium. Confusion. You're in it now. God or man, who you want to serve. Easy for me to want to be under God. Take a little while to get there, but I'm getting there. And I hope that you want to too. So let's get this broke down. Understand you need the law. What's the law going to? Where's the law? It's the contract you're going to create in every instance. He's going to give you the simple steps. Sometimes it's entitled Notice Private International Remedy Demand, or a cause of action, or it's just a hello, how are you? There's no title on that thing. You billed me and you're not supposed to bill me, and you did this, and it leads me to believe you're committing fraud. That's pretty easy. So back to you, Brandon.
All right. So, like he's saying, let's say you send out your notice, or in the letter that was sent out by his sister, if there had not been a response and they continued to bill the $49, were they not in agreement that now this $49 charge is is fraud. So we've got a contract. I've got a claim. What does a claim lead to? Or a breach of contract gives you a lien right. A lien right is equivalent to interest or can give you title. So, in the case of, let's say, the chess set, they agreed to pay $40,000 for a chess set by not responding to the offer. Now, by not paying on the contract, failing to pay the $40,000, that's a breach of contract. So now, I've got a lien right. I've got a $40,000 interest. Did you name a surety on your offer?
Absolutely.
What was the surety?
It was the warden.
The warden. The warden's bond?
No, just the warden personally,
Okay.
because he's not allowed to, he's not authorized to sell chess sets for 40 grand for the BOP or obligate that kind of liability, because you can't go after go after his bond. He stepped outside of his office on that, didn't he? His office doesn't allow him to take private property. So when you want to sue and go after the bond and shut the city down, what are you doing? These people are operating outside of their office. Whose job is it to help keep the servants in line? Isn't it the master? Well, if you're not home, how can you help these poor servants know their job?
So out of that breach of contract came the lien right and the interest and the title. So we can perfect our interest in title through records or through public ratification, depending on where you want to operate. His UCC1 filing, that's just a notice of his lien right. But that now is equivalent and creates title and interest.
It's on.
It's on? Okay. Now, when you say UCC1 filing, when you say UCC1 filing, do you really mean UCC1 or do you actually mean UCC3? You've already done your UCC.
A UCC1 is a financing statement. A UCC3 is an amendment to an
That's
already
right.
existing.
So you're always on a lien. If you want to file a lien in the UCC1, you do a real UCC1. So you create a completely new number. Is that what you're saying?
Completely new to what?
Well, if you,
what's
for
before
example,
that?
if you've done a UCC1, so if I have done a UCC1 myself and I've
But
amended...
who are the parties of that?
Me and my straw man.
I know. I'm trying to unconfuse.
Okay, I get it. So it's between me and my straw man.
Okay. Is this between him and his straw man?
No.
Okay.
I see. So
Two
it
different
has
parties.
to be a completely...
Yeah.
Oh, okay.
Yeah.
Thanks.
There's a new secured party and there's a new debtor.
Excellent.
Okay. And that's fun. That's actually a good question because that's not the first time I've heard that. And I know a lot of people get confused. They think everything must be attached to some UCC1 they did on their birth certificate or something like it. No. That's its own separate claim. I could file, actually I've got probably 15 or 20 UCC1s on various different properties and things of that nature, all with different parties named in them. But each one's its own unique UCC1. It's just a notice. Do I need the UCC1 to record my interest? No. I could take an affidavit. Because a unrebutted affidavit in commerce is what? Law, truth, fact, judgment. So I could just write out an affidavit. So-and-so, the warden of such and such prison, owes me $40,000 for such and such actions, and record that. Will the county recorder record affidavits? Okay. I could put a tracer flag on it called an affidavit of obligation if I've already established the facts, because on an affidavit of obligation you've got your allegations and your proof of allegations, and now I've got a security. This commercial lien can be traded and sold to a bank. It's commercial paper. Am I losing it? Oh, question? Oh, go ahead.
Gordon, when you were, what am I doing? Oh, Gordon, when you did this, did you mention the $40,000 in these first three steps?
Yes.
Okay. Did you tell them that if the chess set is not returned, that the penalty was going to be $40,000, or did you wait and do that on the UCC one?
No, you can't. That wouldn't be right. I would have to. Wouldn't it be right if I said, look, I value it at $40,000. If you'd like to keep it, that's the price.
Okay.
So on each and every one of them, it was mentioned, each of the three steps, because I want to make sure my brother understands what's happening. Of course, when the second step was sent, I reattached the first step. So there's no
Okay.
ambiguity in my
Okay.
communication to him.
Because I got a little thing with library books, which sounds crazy, but I thought I would try this with the library books because I check them out basically for my employer, and they've not been returned to the library, and I'm preparing a letter that I want to send to him, and I'm going to have 2 witnesses when I mail it, that the responsibility, he told me he would take responsibility, and he's not doing that. And there's only a few more weeks before somebody's going to have to pay, and it's going to be me because they're on my library card.
So you might want to give him a hello, how are you?
Yeah.
Brother.
That's my plan.
You asked me at this date to go get some library books for you. I went and got you this book, and this book. I gave them to you on this date. The time to turn them in is past. I've asked you on or about December 1st, I asked you to return them, and I got no answer.
Well, the date
on or
hasn't
about
passed
March,
yet.
I did. I value these books and my lost reputation with the library, the public library,
Okay.
at $500,000. To avoid any damages being incurred, to avoid you incurring any $500,000 penalty for failure to return the books, return them. Or it's agreed that you've damaged me in the amount of $500,000 or $100,000
And
or
that is
$50,000
done
or whatever.
right here on the claim, your cause of action, damages, and liability. That's,
Well, I'm going to my brother. I want to be kind of soft about it. I don't want to be difficult. There's nothing soft about $500,000, but I want to be real polite about this. But you want to do it just like she said. You billed me $49, and that person isn't here, and I want you to stop doing it. And then the little punch, committing
okay,
fraud.
but she didn't put a punch on hers. I'm wondering if this is where I put the punch in.
She put a punch. Fraud.
Fraud. Okay.
For telephone
Okay.
service providers are real bad. That's horrible.
Okay.
That sets a horrible precedent. So your thing is going to be, they don't care if you call him and said, this leads me to believe you're committing fraud. No. This is going to damage me, in my opinion, in about $100,000. So to avoid you incurring this, that means to bring upon oneself. To incur means to bring upon oneself a liability / obligation of $100,000. Return the books by this date.
Okay. Wonderful. Thank you.
Okay, now another way of looking at this. Let's say I'm the recipient of an offer or a notice or a demand. We got 4 doors. If I want to be in honor, I will accept the terms of their contract, or I will conditionally accept the terms of their contract. If I conditionally accept their offer, their claim, upon terms. Now, depending on the nature of their offer, my conditional acceptance may, or it's always a counterclaim, but it may be a counterclaim with cause of action, liability, and damages. So, for instance, the offer of refiling my taxes on a letter 3176C. They've just offered to allow me to correct my return or pay a $5,000 penalty. They gave me two options. Well, I'm going to conditionally accept that. I accept your position of filing a new return, condition upon proof of claim that my original return demonstrates a willful, what do they call it in the, a intent of, or qualifies as frivolous under section whatever of Title 26, that there is any defect in the original 1040 as it was claimed, that there are any defects in the information returns attached thereto. If you cannot provide said proof of claim within 30 days, here's the what's going to happen, then you agree that the original 1040 is true, correct, and complete, and therefore will be sending me my return within 10 days, or within 30 days, whatever I gave them on the conditional acceptance. If you do not respond by affidavit to the points mentioned in the attached affidavit, and again, my attached affidavit would be a negative averment stating no defect in the original, in either the 1040 or attached forms. If you do not rebut it point by point or send me the return within this 30 days, then you're agreeing to damaging me double or triple my return. What do I have? What do I have if they don't respond? I have a claim, don't I? I made a conditional acceptance of their offer. It turned their claim into my counterclaim. So now if I have a counterclaim that's not responded to, what do I have? A breach of contract? What does breach of contract give me? A lien right. For triple what my return was. So I can compel the performance of the trustees in this matter. Everything's a trust, is it not? Mm-hmm. How do we look at these as trusts? If I'm the recipient of an offer, what does that make me? No. If I'm the recipient of an offer, I'm the trustee. I'm the one holding the paper. I'm the one who must perform. If I take that and invert it with a conditional acceptance, now what am I? I'm the beneficiary who can compel the performance of the trustee, the new recipient. The recipient of the counterclaim's now the trustee. We just inverted the trust. Isn't that what we do when we accept and return our birth certificates? Invert a trust. If I return on conditional acceptance a claim that inverts the trust relationship from me being the trustee, the IRS being the beneficiary, to me being the beneficiary and the IRS being the trustee, and I can compel their performance, that's trust law. And are we not operating under trust law? Everything's contract, everything's trust if there's no consideration. We've got meeting of the minds. They didn't respond. They're in agreement.
Hey,
Anything?
Brennan,
Yeah.
we hear different people use different amounts of time for people to respond, to give people to respond.
Right.
Are we following certain principles in order to decide how much time we're providing for them to respond?
In reality, if you're serving them by mail, they only have 3 days. Now, because it's by mail, you got to allow 3 days for the mail to be received, 3 days for the mail to be returned, and 3 days for them to process, and 1 day for a Sunday. That's a 10-day process. If you give them 30 days, guess what? If they wait the 30 days, they're in default automatically. You can choose anything, any time limit. But just keep in mind that if you give them a 72-hour time limit, and you're doing your process by mail, you're actually giving them 10 days. You must account for mail out, mail back, 3 days that you're giving them to process, and the 1 day for a Sunday.
I was wondering if they come back with a letter like the IRS did to me that says, we got your letter, give us 45 days. What is that? How does that change the equation?
It's counteroffer. I accept your position of taking 45 days, condition upon proof of claim that it's going to take you 45 days to cut a check, or 45 days to state a claim. If you cannot provide that claim or that check inside of 10 days, because again, what are we asking them to do? To do it under affidavit. Okay, I'll give you the 45 days. I want you to swear under penalty of perjury and under your unlimited commercial liability that it's going to take you 45 days to state a claim or to cut a check. That's the only two options they have. But you got to bring your offer back. See, they're making a counter offer. If you don't bring your offer back in, you've abandoned your original claim. Keep that in mind. Now let's say I'm dealing with a CFO and I've established my facts of his fault on my process and I'm getting these responses from this third party at the bank. Who is this third party? Is he not perhaps my data integrity board? My second witness? Perhaps the CFO cannot act as a fiduciary unless he gets a second witness from someone in his corporation of the facts. Well, I'm going to conditionally accept whatever this third person wants to allege, bring my claim back on top, and send them a copy of the record of what I've already have going with the CFO. Now what do I have? A second witness to my facts, to my contract, to the agreement. But never abandoning my original claim. If I start arguing with this guy, I've abandoned this claim over here. With the CFO, it's gone. I abandoned it because I decided I want to argue with the Data Integrity Board.
Brandon, we're looking at this third-party interloper that comes back after the CFO. We're looking at him now not only as the Data Integrity Board, but at the appellate court. And the reason we're looking at him as the appellate court is because it takes two witnesses to everything. And remember what we're doing in your dual trust. Our letter to the CFO and our offer to him was literally coming from above the line, which is in the private trust, to the CFO, who's the private party for the public corporation. So he's kind of like sitting on the line too. If you want to look at your straw man, which is the Tin Man and the Scarecrow, if you were to pull those block 2 and 6 right up to the line, actually your straw man character, your corporation, is private and public. There's one side of it above the line and one side below. Their corporation is also public and private, and their CFO is on the private side of the corporation on that line, and the rest of the corporation is public down below. Okay? Now, there is a purpose for a trial court and there's a purpose for an appellate court. The trial court looks at the facts. The appellate court looks at the law. So that when you go to appeals, the appellate court cannot look at any new facts. Whatever the facts are already in the record that comes up from the trial court. So remember, we're saying there is no law, so there is no judicial in reality. All you've got is administrative process, private law. So your trial court is your private administrative procedure between you and the CFO. So what you sent the CFO, did you get anything back from the CFO? No. What is the rules in administrative process? The first party that leaves the field of battle loses. So if the CFO didn't respond to you, he's left the field of battle. So you can look at it as a commercial loss, or you can look at it under the rules of procedure or the doors we're talking about, he failed to respond. If he failed to respond, obviously he has no disagreement with what you've done. He's basically in agreement by failing to object timely. So did you win the trial court process? Yeah. Is there any argument? No. Why, when Martha calls you up and says, well, you still haven't paid your utility bill, why are you arguing with Martha? Your court trial is over and you won. And your proceedings was in private because your offer was from the Republic. So can the Republic see your private set-off funding that you're agreeing to compensate the corporation with? Yes. Can they see that private set-off funding in the democracy? No. Doesn't Martha telephone you from the democracy? And you're going to explain to her that you got a fund in the Republic that paid her? Aren't you re-arguing with Martha? What is the jurisdiction of that trial proceeding? It's in their public. It comes from the democracy. So you're now re-arguing your trial the second time in the democracy with a party that wasn't even involved. Isn't that called a trial de novo? Well, if you went to trial de novo, is that plan B? Oh, I already beat him in plan A in my trial in the Republic. Now I'm going to beat Martha under plan B. So you've abandoned plan A. But you can't get a remedy in plan B because the law from the jurisdiction of B does not recognize your payment. But if you treat Martha as the appellate court, she doesn't sound like that when she calls up. She goes, oh, I'm from the utility company. We're going to turn off your account tomorrow. Why don't you turn around and say something like, oh, I get it. You're the appeals court. Could you give me your name and your mailing stop so that I can send you the record of the trial on appeal? And by the way, I'll send a copy of the record on appeal back to the other party in the matter. Who's the other party in the matter? CFO. Is he getting the same documentation twice? Double witness. You're treating Martha as the appellate court. Does Martha have the ability now to rehear the case with the facts? No. She's the appellate court. The appellate court can't rehear the facts. What does Martha have to do? She has to interpret the record with the law of the case. Can the appellate court attach the law? Yes. What is the law of the case? It's the law of the jurisdiction of the offer of the contract, which is in the Republic. Under the law of the Republic, can they see the source of the funding? Yes. So they have to concur with what you did. You understand what's going on? Now, if Martha decides against you, or if she goes bonkers on you, then you've exhausted your administrative route and you can go to the quasi-judicial for review because you've exhausted your administrative remedies. But we got to treat her as the appellate court. We've had a couple people do that, and the Martha goes, Oh, I'm sorry. Oh, you want to submit a record. Don't send it to me. Here is the address and the location and the name of the party for that record.
By interest, what department was Martha given?
It sounded like collections or legal or something like that. I don't care what it is because the contract's already been set. They can't change the facts.
Right, but she's directing you to, that's the appellate division over there. You send them the record. I'm just their patsy. They have me make the calls.
Yeah, she just wants to get an argument out of you to abandon your claim.
Yep.
Okay? Now, what you were saying before, too, when we're on that chart up there, when it comes to a case, 99% of the time, the plaintiff in a case is who? A trustee or a beneficiary? A beneficiary. Who is the defendant? The trustee. Okay? Now, under even the common law of the land, there was a presumption that the party that was charged or accused was innocent until proven guilty. Under the Admiralty, it's the opposite. The party that's charged is assumed guilty unless that party rebuts the presumption. So if your straw man is charged, the straw man has to rebut the presumption if he's going to go into court and litigate, or else he's presumed guilty and the plaintiff doesn't have to prove a case. So the trial is a total waste until the defendant comes up and rebuts the presumption. Okay, here's your problem. In the bottom chart, 5 and 6, who is number 6? Is that your straw man? Is he a beneficiary or a trustee? Beneficiary. Box 5. The complaint comes out of an attorney or a trustee for the United States or this corporate state. The trustee is the plaintiff and the defendant is the beneficiary. What the hell's wrong with this picture? Why are they doing that? It's not right. Agreed? Look what they did.
They appointed you a corporate officer.
What happened is they served paperwork from the trustee of corporate United States or Illinois, and they put a complaint on the straw man and put the charging documents in the straw man's hand, right? When the straw man received those documents, what did they just do? He appointed you as a trustee to resolve the real trustee's problem. You're a co-trustee. What happens if you keep those documents? You've accepted the appointment, and now they're the beneficiary of the fact that they appointed you as the trustee to settle a case. So they did an inversion. How do you reverse that? Do an acceptance and return of the paperwork. And you're reappointing them as the trustee and you're back to beneficiary. By holding the documents, it's the game of hot potato. By holding the documents, you accepted the appointment of trustee. And now you're liable because of your actions, which are louder than the titles and the words for which you are. You don't know how to process this proceedings. You've accepted an appointment, and by holding the document, you've now become the co-trustee under them, and they're the beneficiary of the fact that they passed on their obligation to you. Voluntary consent.
See? You don't have problems. They're passing you their problems.
Offer and acceptance.
Yeah.
Jack, my question is, when you're dealing with Martha, and she's called you up on the phone, and it could be anywhere in that three-part process, like the claim and the opportunity to cure and the other piece. When you're dealing with Martha, you're not sending her a new claim, really. You're not going to be doing this three-part again with her. Is that true?
Martha's in the public.
Yeah, Martha is the second agent for the company. You dealt with the CFO.
Right.
So you did an A for V, R for V, sent it back to him. You may have done the set off, or you may have done a monetary instrument to compensate the corp. Okay?
Yes.
You didn't hear from him. Now there's a very good chance that 10 days, 30 days hasn't gone by. You haven't put him under notice of fault. You haven't got a certificate of protest. But you did send him, let's say you sent him the A for V, R for V
Yes.
on the contract offering, the statement. Let's say you fill out the coupon. If there's a monetary instrument because you're doing it commercial instead of set off, you did that. You sent a 1099-A, the copy, the B copy to the CFO. The original is filed with the 1096 with IRS. And whatever other documentation, that is your record.
Okay.
Now, the CFO has not answered you, but you get Martha's call. The problem is you're going to assume, since there wasn't any response by the CFO, there is the watchman theory in law, the duty that if you did something wrong, somebody has to tell you you did something wrong. Because if they see you did something wrong as the watchman and they don't tell you, they're liable for the damages. So if somebody didn't tell you you did something wrong and they're trying to come back against you, they're still liable because they didn't warn you.
Right.
Likewise, you have to warn them if they did something wrong, like failing to respond, which is why you sent out the second notice, etc., so that you give them the same due process and equal protection that you want them to give you.
Yes.
But when Martha calls you, you've got to sit down and ask yourself a question. Is Martha calling as the appellate judge to give you your second remedy by going to the law decision? Or is Martha calling you as the watchman on the wall to tell you you really screwed up and you better correct your process? So just because you get a call from Martha, do not jump to the conclusion that, oh my God, I'm winning this thing, I'm going into appeals. Because if Martha's calling you and she says the same thing, man, this is all screwed up, we don't know what you're doing, that either means I'm ready to be your appellate judge if you don't want to argue this and you want to proceed. Or she's saying, I'm the watchman on the wall, you screwed up, really, and everything you did is of no force and effect, so you better correct it. Well, if you've determined that what you did, you can sustain, it's valid, then you got to assume Martha's in appeals, and that what we're waiting for is the appellate record to go in. Now, you didn't give a second notice, and you don't have a certificate of protest, but you got all of the process of the record, and the CFO didn't answer.
Okay.
Okay?
Okay.
If he didn't answer, did he return your process? No. Under the UCC, it says that if you've accepted the process and kept it, you're liable on it. So you got the UCC going on your side if your process is correct.
Okay.
So you're just submitting your record, and what you need is the second witness. You need the law to be attached to the case. This happens in IRS all the time. If you're dealing with IRS and you do an administrative process to set off a claim, if you're winning, IRS is going to send you a notice of lien and levy. When you get the notice of lien and levy, go out and party, because that means that you're on the right track. Or it means you totally screwed up your process, because it's either the watchman on the wall saying you blew it, or it's you need to go to appeals. Because you can't go to appeal and set the law to a case when there isn't an actual dispute going on with damages. Because the Supreme Court said back in the 30s, we will not hear a pretended case. There's got to be actual controversy with damages. Until the IRS is going to lien and levy your account, you don't have a damage. There's nothing in controversy. All there is argument. So when they say, we intend to lien and levy, they're going, okay, dude, we're coming out and taking your property. So there's an actual controversy with a potential damage here. So it becomes a judicial case at that stage of the game, even though it's like administrative. And so therefore we can go on appeals because an appellate court can attach a law to what's going on because there could be actual damage. So about the time IRS says we intend to lien and levy, everybody's going, oh my God, what's going on now? The issue is they usually send you notice of your appellate rights. And in the notice of appellate rights, they give you two types of appeal. One, you have to ask for the appeal within 30 days of the date of the notice, not from the day you got it. If you ask for that appeal as of right within the 30 days of the date of notice, they said if you submit your record on appeal and we agree with your record and rule in favor of you, we will abate the lien and levy, and if we seized any collateral, we'll return it. That's exactly what I want. The abatement. Stop it. Okay? Because then you win with a legal decision on appeal. Now it said that if you ask for the appeal outside of the 30 days, that if we rule against you, you have no rights of judicial appeal whatsoever. But if you ask for the appeal within the 30 days, that form of appeal, and we rule against you, you have the rights of judicial review in a court. Now remember, under the Articles and Amendment to the Constitution of the United States, it says that any actions in controversy in excess of $20, you can go to a trial in judicial. So if you're asking for the appellate right with the one within the 30 days, they say you got judicial review. That would be the form of appeal you're asking for if you have a right to judicial review. When would you have a right to judicial review versus when don't you have a right to judicial review? Answer is very simple. You have a right to judicial review if you have a claim. You don't have a right to judicial review if it involves only a privilege or a benefit. So what's the difference between trying to get a privilege and benefit versus a claim? A claim means that you have legal title to the collateral subject matter in the proceedings. So IRS wants a tax. Did you pay it with Federal Reserve notes on the public side? If you did, you have not got a title in that because all you're using is liability to set off another liability. And you have no claim. You're just equitably balancing the accounts of Toby the slave with the tax collector. But if you used a set-off coming out of your asset account, doesn't that asset account, don't you have both equity in the amount of the funds and legal title control over the substance of the funds coming out of that account? So if you're doing a set-off to settle and close an IRS debt, you've actually got a claim if you're bringing your compensation from the asset side accounting because that's your title on those funds. So it's a property right and a legal claim. So if you're using the set-off and you submit that to Internal Revenue, and let's say you sent it to the CFO in IRS just like you sent it to the CFO for your utility account. What's the first thing that IRS is going to do when you do all your process? Fail to respond. You hear nothing whatsoever from the IRS CFO. What's the next letter you get? We intend to lien and levy. What are they telling you to do? Martha said, oh man, we're coming down hard on you because we still got this account here, and the account isn't settled. What do you have to do to IRS to get it resolved? Go on appeal to get your second witness. And in the intent to lien and levy, they say, we intend to lien and levy. If you want to stop us, ask for an appeal. They're doing the same thing as Martha. But at that time, what does everybody do to the intent to lien and levy? A conditional acceptance for value in return. Why are you continuing a new contract with a third party in the corporation when you've already won on your first contract offering and you need to get an opinion on winning on that first contract to solidify the settlement instead of opening up a new contract with a third party, which just keeps it going on and on and on. So this appeal is extremely critical in trying to solve these, and IRS is the easiest ones to resolve it with because they just flat out tell you once they don't respond that we intend to lien and levy, go on appeal and we'll see if we can help you.
That was gold.
I had a question about when you're talking about the appeals for the notice of lien and levy, you're talking about requesting a CDPH hearing. Is that what you're referring to?
Talking about a what?
A CDPH hearing, a collection due process hearing?
Oh no, that's what they'll talk about. Okay, but once again, they're trying to seduce you into the public side of everything. See, haven't you just done a private administrative procedure? Okay, they're going to talk about two appeals. They're going to talk one type of appeal in IRS, due process. We don't want a collections thing. Why do we want a collections? We want them to look at the record of settlement. And we don't want to do anything in the IRS public statutes. Who do the public statutes apply to? To the debtor. Have we come back to the CFO in a debtor capacity? That's what they're trying to seduce you into. We would come back and we would demand an appellate hearing as of right. If nothing else, we could purview it through the Title V Administrative Procedures Act, where we've exhausted our administrative remedy, and we're demanding an appellate hearing on the record for the administrative procedures, not under the statutes of Title 26, which isn't public law, which means it has nothing to do with rights whatsoever. You understand? But we still got to ask for that appellate hearing under Title V as of right within the 30 days. Because if you go outside the 30 days, your time has expired for an appeal as of right. If you're in a law court and you lose a civil case in the law court, how many days do you have to put in a notice of appeal? 10. If you're 1 day, 10 days under admiralty is the time to put in a notice of interest. And then 20 days after that, you have to file your claim under the what do they call it? Admiralty Rules of Civil Procedure in Federal. And the Admiralty Rules are Rule A through like J or K. And under that procedure, you'll find out that if the government seizes property that is yours, you have to file a notice of interest within 10 days. And then you have to file it up with a claim within 20 days, or you're abandoning your title and interest in the property the government has seized. But admiralty is where they're operating all across the board. It's just obvious in admiralty. In civil and criminal, they try to shade it and conceal what they're doing. But all civil and all criminal is under admiralty anyway. So you look at the rules of admiralty, it tells you flat out what you're supposed to be doing. And then you look at the civil and criminal rules, and they're a little bit colorable, but they're going to tell you about the same thing. So we're not asking for a privilege under Internal Revenue rules. We're asking for a process as of right under the Administrative Procedures Act, okay? You see the difference? Otherwise, you're in the public side of what they're doing. And chances are when you submit this record to IRS, it's going to go in there, and if you've done everything correctly, you will get a ruling out of IRS within 10 days, usually, and it will abate the proceedings. It'll reverse it.
One more question about that. If you send...
Get on the mic for our tape, please.
Let's get on the mic.
If you send a conditional acceptance letter when you receive your first 3176, you don't have to wait to get a notice of lien or levy to administer your right under the Administrative Procedures Act, though, right? I mean, you can take them to court at that process if they fail to...
Which court...
Well, I'm asking this as a question.
Which court are you taking them to?
Well, that would be...
Are you going to file as a plaintiff?
That's why I'm asking the question.
In the public court?
It would be the judicial court.
And who is it that's got the case there? You say you are going to file. Who are you, Kim Asadi?
I am who I am.
I am who I am is not recognized as a party in that court.
Well, I am the authorized
Popeye?
representative of the person that's filing.
You could be an authorized representative, but why are you filing in an alien court? Once you file in their court, what did you just contract with them in their jurisdiction to hear your claim? So you've got to watch what you're doing, because you're going down into the public to file a case, and you've got to watch public policy. Now, I'm not saying as an alien and a foreigner you can't get a remedy in their court, but you've got to watch very carefully what you're doing. In the Amistad case, who were the defendants? Yeah. Foreign aliens. But what were the defendants charged with? Violations of federal law in the presumption that they overpowered and killed the captain and the officers on the vessel SS Amistad. So they were charged under criminal law because you can't go against the captain of the ship. He's the law of the ship. So it's mutiny, it's whatever, and they were charged under federal law with a crime, a criminal act by which they could have been killed because of what they did. Now, none of the defendants spoke English. None of the defendants spoke any language that anyone in these courts could understand. And there was a young whippersnapper attorney that decided, this was back in the 1840s, it's the subject of a movie that came out a number of years ago, and it's an important Supreme Court case. Ex-presidents of the United States were attorneys that dealt with the appeals on this case. And the young attorney that set it up suggested strongly that the defendants were not guilty of the crime of murder and insurrection and killing the people on board. Why? Because the young attorney said that it appears as though the defendants were illegally and unlawfully captured in their foreign land and induced to be slaves in violation of international law. And when they were induced to be slaves, they could use whatever level of appropriate force, including murder, which would not be murder, in order to secure their liberty and freedom because they were illegally and unlawfully seized. Now, there was supporting evidence as to why he brought that claim. And in the end, the defendants were set free because they had been captured illegally and were allowed to get their freedom back by use of lethal force if necessary. They were aliens and foreigners from someplace in Africa that were being defended as defendants in an American federal court system. And even though they were alien and foreign with the appropriate pleadings, they could get a remedy. So I'm not going to say that you don't have the power to go into that court as a plaintiff, because as a plaintiff you would have been a beneficiary if you were in the position of having secured whatever you needed to. And you could have sued them as trustees for not settling your case. But you see, they colorably have it set up so that you don't have to go to judicial proceedings. Most likely, if you went to judicial, the judge would dismiss it on failure to state a claim. Because he'll say, you have not exhausted your administrative appeal right yet, therefore we can't hear you. The IRS is setting up your appellate proceedings in their procedures of their letter writing campaign. And they give you the opportunity to accept and return the offer for appeal and submit your record, by which you will get an administrative remedy which will never appear in the judicial court dockets, which is exactly what they want, because they don't want to blend the public and private with what you're doing and what they're asking. If you start filing things in the court in order to sue these people, even if you prevail, they're going to have to seal that record or do something, and they would just as soon not have to do all that crap. So they want to keep it on the administrative private side, first with a private trial, then with a private appeal. Does that answer your question?
There was an exceptional little piece of gold in there too that I'm not sure if everyone got it. Did you hear about the 10-day, 20-day on the seizure of any property? Keep that in mind. That's a very powerful piece of information. And all you need is that knowledge and how simple it is to actually a notice of interest. Notice of interest. I have an interest in the funds from account such and such and such from this bank. This is the amount of my interest. Within 20 days of that, your claim to it. You've now got an administrative process in which you can get a return of any property seized. I think that's good to know. Alrighty, we're at dinner here.